Good afternoon, everyone. This is Rajiv Khana from immigration.com, the law offices of Rajiv Khana PC. Apologies, I'm starting a couple of minutes late. We kind of got hung up with a bunch of questions before the call. Okay, so as always, you would have heard all the disclaimers when you logged in. Those disclaimers apply. I'm going to go over, already we have so many people in the call, I'm going to lock the conference. I just want to make sure I get everybody who's here. So give me 1 second.
The conference is now locked.
Yeah, so there's a whole bunch of people here. I want to make sure that people who have questions, their questions do get answered. The way we will do this call is as follows. First, I will answer the posted questions. Within the posted questions, I will answer those questions first that I have marked as frequently asked questions. Each time I answer a question, I will request people, if they have any follow-up questions on the topic that I have discussed, to go ahead and raise their hand by pressing *5 on their phone. Okay. So every time I discuss a topic, I ask for follow-ups. If there are no follow-ups, I move on to the next question, and so on. We'll finish the posted questions, and then we will start on new questions. Okay. So please hold any new questions to the end of the posted questions. That said, let's begin. First frequently asked question. So my EAD is delayed. What are the options? Well, it kind of depends upon some EADs where you might have the option to continue working, but many EADs you do not. So for example, here, if EAD is delayed, and the employment is no more valid unless EAD is received, does the employer have to terminate the employee? That's a good question. Okay. So do they have to terminate the employee? The answer is no. If the employee does not work, they can continue to be on the payroll as leave without absence. They can continue receiving their medical benefits or whatever other benefits they are getting. They just should not work. Okay, because if they work and they get paid, then it's unauthorized employment. Even benefits. Okay, can they send an employee to leave without pay? Absolutely. Or both can be done. It's up to the company. That is also true. If the company wants to lay off the person and then hire them back, that is also possible. *5. If you have a follow-up question, press *5. Remember, no new questions, only follow-ups. All right, let's see. This one is area code 720, which is Colorado. Colorado, go ahead. I can hear you.
Yeah, hi Rajiv ji.
Oh,
my
sir.
question is, this question was specific for EAD. What about L2S? So L2S doesn't need a EAD. It's automatically, eligible for dependent employment.
It's a similar situation in some ways and dissimilar in some other ways. So even though L2 dependent L2S is entitled to work just because they are L2S, but if their status is expiring, they cannot work, right? So I have
the L2S.
Go ahead.
I'm saying the new I-539, like extension of the stay, is already in process.
Right.
We have the receipt notice, but it's not approved yet. So it's
Right.
the same situation, right?
So if I remember correctly, I haven't looked at this issue specifically. If I remember correctly, there was a weird notion. L2S might be an exception. I know that for H4 EAD, this is a problem. So you can double check this. When you go to their, if you just Google USCIS automatic EAD extension, you'll come to a page which tells you exactly what to do in which case. For H4, they said you have X number of days to continue working, but only if your I-94 is also valid. Okay. But if your I-94, if you apply for a timely extension of your EAD, you can continue working as long as your I-94 is valid. So that's a catch-22 because most people's I-94 and H4 is expiring at the same time. I don't remember if something similar applies to L2. Please double check. I think it's similar. You can't work.
Okay, because in our case, L2S and I-94 is expiring on the same day.
That's what happens.
Because L2S.
Yeah, that's what happens in most cases. So it's really not that big of an advantage to have an automatic extension. But please double check. L2S may be different than H4. On that page that I mentioned, it should tell you clearly whether you are subject to the same rule or not. All right?
Okay, thanks, Rajiv.
Good luck, sir.
We'll look for that page.
Yes, sir. Let's go to Florida. Yeah, Florida, go ahead. I can hear you.
Hey, so this is my first time applying for any EAD. I am currently doing my full-time CPT, and my full-time CPT is basically transitioning to OPT as well.
Okay.
The issue is I talked to my DSO and they said that usually it's taking more than 90 days. And I just applied 2 days ago, and they said that my start date, which is 3rd August, might not be reachable. It is a possibility that my EAD is not.
Hold on. Is there a reason why you cannot premium it?
No, there's no reason.
So
I was just, again, this is just a follow-up question on.
Yeah, so that makes more sense to me. But also, please double check with your DSO or your International Students Office. The fact that you have taken full-time CPT, have you not lost your OPT? Just double check that.
No, so for the whole of last year, I was doing part-time CPT. And the full-time is only, I think in total 20 weeks, including this summer.
Just make sure that you qualify, let them do the math. But if you do qualify, then it makes sense to premium it. I think that's just money well spent. Okay?
Okay.
Good luck.
Thank you.
You're welcome. All right. So let's go on to the next frequently asked question, folks. Let's see. I thought there were more. Did I miss something? Oh, here it is. Benefits of National Interest Waiver. Now, I have been answering this question at least once a day, sometimes more than that. So, first question is, first let me tell you, if you Google my name, Rajiv S. Khanna, Economic Times, you'll come to my page on Economic Times where I have explained the benefits of an NIW, excuse me, even for people from India. Okay, so review that article. I'll kind of give you an overview from what I remember. Benefit number 1, you get your priority date. So you've got your I-140 approved under NIW. That is your priority date, the date you filed the I-140. Okay. So that priority date can then be transferred in future to any EB1 petition or another EB2 if you end up for whatever reason doing another EB2. That is the first advantage. You get your priority date. Second advantage is once your NIW is approved, you carry that green card with you in most cases, unless the petition is not drafted carefully. The NIW goes with you no matter how many times you change the jobs, as long as you are in the same field as stated in the NIW. So the green card becomes portable. You don't have to keep doing green card applications over and over again. Third advantage is, based upon that I-140, the NIW I-140, you can keep extending your H-1B with any employer even past 6 years. The fourth advantage is your wife or your husband can keep getting H-4 EAD and H-4 EAD extensions with you. So in other words, they because of the I-140 approval, they become eligible to receive their employment authorization. And the last one is, under some cases, people who have an I-140 approved and their priority dates are backed up, like people from India, they can get compelling circumstances EAD. So based upon the I-140, in some cases, I don't like that provision very much. It has too many issues. But we've done that a few times. It works okay in very specific circumstances, but that's the last benefit. So the question that was asked, what are the benefits to file EB2 for a person whose I-140 is already approved with an employer? Not very many. The only advantage then is that you become the master of your own fate, because you can have multiple I-140s approved and you will always carry the priority date of the earliest one. Okay. Can you get your I-140 approved priority date to your NIW? So what you're asking me is, my I-140 is already approved And if I do an NIW, will I carry that old priority date? Yeah, absolutely, you will. Second question, is it possible to renew H-1B stamp before the expiration? For example, this is an unrelated question. If my H-1B is expiring in November 1st and I go for visa stamping in October with approved extension, there's a limit. I think they renew it as early as 4 months, but I don't remember for sure. You can check with the consulate, send them an email. It can be done. There's no doubt about that. The only question is how early. And that I don't remember. Okay. *5. If you have a follow-up question, press *5, please. No follow-up question? Okay, good luck. Good. Let's go on to, there is a follow-up question. Guys, you gotta be a little quick. This is California. All right, California, go ahead. I can hear you.
Hey, thanks for showing up the option of National Interest Waiver. So I was looking at the article from Economic Times. So is this National Interest Waiver for U.S. permanent residents can be applied after the completion of master's degree, or we can do it while studying?
So there are 3 sets of people who can apply for NIW qualifications wise, not the whole petition, just their own qualifications. Number 1, if you have a master's degree. Number 2, master's or higher degree. Number 2, if you have bachelor's plus 5 years of experience. And number 3, if you are exceptionally qualified and you meet 6 out of 3 criteria, like 10 years of work experience, a degree, etc., etc.
Okay, and is it the same process as the Perm process we usually
do
after getting employment?
No. Okay. This one doesn't require an employment. It can be done without an employment. And number 2, you don't go through Perm. You just directly apply the I-140. You skip the Perm altogether. So you save about 1.5 to 2 years. Okay.
Okay. So, and this process usually saves time. Okay.
Well, there's no guarantee you're going to win, but in proper cases, this is a very good way to go.
Okay. Thank you.
You're welcome. Good luck. So we covered the benefits of National Interest Waiver. I think there was another frequently asked question. Well, doesn't look like there was one. Okay. This I covered already. I'm just scrolling through my questions. I think we have a total of 13 questions. I think we dealt with 1, 2 only. Okay, no more frequently asked questions. Next one this is question number 3. Impact of Perm denial and long H-1B extension on future H-1B green card. Okay, my 7th year H-1B extension was approved till 2024. Perm was denied. I discussed, they told me to file an 8th year H-1B extension before 23rd January, which will take 4 to 6 months. In between, we'll file the new Perm for me. Oh, no, that's a bad idea. I would have done this differently. I would have filed an appeal against the Perm denial. An appeal typically stays pending for 3.5 years. Okay. So what I normally do is, while the appeal is pending, I get my H-1B extension and I time it so I can file a second Perm after having done all the prevailing wages and the advertising and everything done all over again. Appeal continues pending. Just before filing the second Perm, I make sure my H-1B extensions are intact. I then file the new Perm, and that becomes the basis of further H-1B extensions. That's the way to do it. My 8th year has been approved from 10th January 24 to 9th April 27. Well, that appears to be an error, right? So if it is an error, you are not allowed to take advantage of it. If you are only entitled to 1 year, you should take that 1 year and forget about the mistaken extension given to you. From 23rd Jan to till now, I have valid H-1B status. 8th year, yeah, while your H-1B is pending, extension is pending, you are in legal stay, okay? And you are even authorized to work for up to 240 days or as long as the case is pending, depending upon how the case was filed. Then are there any issues? So just that, don't take advantage of a mistaken extension. Still, I am eligible for Perm filing. If I leave USA after filing new Perm, can I come back to the US? And the answer is sure. As long as you have your H-1B and the job, you should be able to come back. *5. If you have a follow-up question, press *5 on your phone, please. All right. So there's a follow-up question from, let's see, from Virginia. Okay. Yeah, Virginia, go ahead. I can hear you. Virginia. Area code 757. Go ahead. Okay. Let's move on to the next question, number 4. Jobless on B2 visa, can I extend for continued US job search? So yeah. So if you have applied for a B2 conversion because of a layoff, and while it is pending or even after the B2 is approved, you need another 6 months, you can certainly ask for it. There's no law that says you cannot. How many days before the current expiration should I apply? As long as your application for second extension is received by the USCIS before the first extension expires, you are fine. It can even be on the last day. They have these suggested time frames like 30 days, 60 days, something like that. But most of the times they are okay even if it gets there 1 day ahead of the expiration of the first B2. If my H-1B is valid till May 25, I decide to go back to India. Can I come back, find a company? You can't travel back on that H-1B visa because you need a job and a valid H-1B status. So traveling on that H-1B without having a job would be a very bad idea. That can lead to debarment from coming to the US forever. I have an I-140 approved. If I decide to go back to India and come back after a few years, like 2-3 years, is it possible to come back? This is a long discussion. I won't be able to cover it completely, but your priority date is safe. You should be able to keep getting your H-1B extensions, but you do need an employer. And if it is the same employer, you might be able to save your green card as well as your H-1B. But if it's another employer for your H-1B extension, you should still be able to keep the priority date, but you have to start the green card all over again. That's the summary. Okay. *5. If you have a follow-up question, press *5. I see a hand up from Tampa, Florida. Florida, go ahead. What is your question?
So recently, previously I asked the question, I got H-1B laid off, and currently I'm planning to go to F1. And if I go to India, let's say F1 stamping got rejected, can I come back on H-1B if I have a job?
Yes, if you have a job, they have to do an H-1B transfer for you. You can come back using the new transfer and the old visa if the visa is still valid, or if they just do a transfer and the visa has expired, you have to apply for a new H-1B visa at the consulate. That's all.
Okay. Thanks.
Right. Good luck. All right. So let's see. Oh, bunch of people have their hands up. Let me first go to, let's first of all cover this. Let's go to area code 682. Area code 682, Texas. Go ahead, please.
Hello, Rajiv sir. So
Hello,
I'm
sir.
the one who posted that question. So
Okay.
yeah, the recent update is last week I got the job, and the company is going to start with all the H-1B transfer. So is it like, so if the company files before May of 27, so I don't need to file a B2 transfer, right? Or if the
Yes.
company files after May 27, so
Yeah.
Okay.
So if your 60 days grace period are expiring on May 28th, your H1
sir.
G?
Yeah, so my B2 6 months is expiring on May 27.
Okay. So then by May 26th, if they are expiring on May 27th, by May 26th, USCIS must receive your H-1B petition in hand,
Okay.
or you just file for a B2 extension online. If they receive it before the expiration of the current status, you should not have to apply for a B2 extension.
Okay, and I'm legally, I can legally stay in the change of status. Right?
Yes, because you have a timely filed change of status application from B2 to H1. All right?
Okay, sir.
Good luck.
Yeah, thank you so much.
You're welcome. All right, so let's go on to the next one. That is area code 973. Newark.
Hello.
Yes, ma'am. Go ahead, please.
Yes, sir. So this is Ashwini. First and foremost, thank you for your help.
Of course.
So I have applied for B2 extension and I got RFE. Tomorrow, like yesterday, I received it, and they gave me June 7, 2024 to provide the document. Right. And what they asked is submit evidence to establish that you have made arrangements to depart the U.S. upon completion of your temporary stay. Mm-hmm. Such evidence may include an airline ticket or other proof of your departure transportation arrangements, or evidence to show that you have the funds necessary to secure your timely departure from the United States.
Right. So what you would do is, were you on H1 grace period when you went to B2?
Yes, sir. I was on H1B.
Yeah. So you would say that obviously I'm looking for jobs, but if you don't give me extension, then I would be happy to leave the United States. And here is my bank statement showing that I have the money to travel, and that should take care of it.
Okay.
All right.
And should I show the airline ticket or the...
No, that would be a waste of your money. Why should you do that? No, absolutely not.
Okay.
All right.
Okay, sir. Thank you so much.
Good luck, ma'am.
Yeah.
Okay. Let me go on to area code. Wait, which one just I pulled up? It is... Wow, I can't find you. Oh, yeah. Area code 320, Minnesota. Minnesota, go ahead, please.
Hi, Rajiv. Actually, my question is, I'm jobless on B2, and my it has been approved, and I have time till July 25th. So if I don't find my job till that time, can I go to F1?
You can convert from B2 to F1. You can also do B2 extension. Sure.
If I go on F1, what's the time period? Till when can I apply? When should I apply for that stuff?
Well, that depends upon, you have to coincide with your course start date, no? So you have to coordinate with your DSO.
So if I apply for fall, the class starts in August, right? And I have time period till July.
Yeah, I would file right now.
What happens?
I would file for change of status right now.
Oh, okay.
Okay.
So, I'll start that then. Do I have to exit the country for this change, or is it possible to do it?
It's within the United States.
Okay, that's all I have then.
Good
Thank you,
luck.
Rajiv.
You're welcome. Okay, next one, let's see, area code. This looks like California. Yeah, 310, California. Go ahead, please. Area code 310. Go ahead.
This is Vinod.
Vinod. Yes, sir. How are you?
This is very good. How are you?
Good.
This is for my EAD. Can I ask the question?
Sure.
So I have applied for my EAD extension. This is my first time EAD. I'm completely on EAD. My H1 is going to be expired in September. But still, it has been 75 days that I have not got an extension. So after September 12th, see that some 540 rule is applied. Maybe I'll be eligible for this.
I have no idea. You're asking the question at the wrong time. Actually, you jumped to the queue. I didn't realize you were asking an unrelated question. But since you have asked it,
Sorry.
Yeah, that's okay. Don't do it again. But the rule applies in very limited and exact circumstances. When I don't know which kind of EAD are you going to.
It's an employment-based EAD.
Is it a 485?
485.
Okay.
85 employment-based.
So you are going from H1B to 485?
I applied for the green card and then I got my EAD. I'm working on EAD right now.
So you've applied for EAD extension. You applied for EAD extension. Sir, have you applied for I-485 EAD extension?
Yes.
Okay. So there is definitely 180 days period that you can continue working, but double check, it might even be 540 because they expanded the times. Okay. Good luck. All right. So, all right, let's go on to the next question. Guys, don't ask questions out of turn, please. This one is question number 5. F1 OPT to H-1B transfer. Can I change jobs before October start date? Well, I've discussed this. This is in our frequently asked questions. You can see the discussions. In my view, because of that ruling in 2023 where the government kind of threw some doubt about what is the proper thing to do, my first preference is after October 1st, go work with the employer who sponsored your H-1B at least for a few pay periods, 1, 2, 3, more the better. Then apply for a transfer. That would be first preference. Second, if you just don't have the option to do that, just request the employer not to revoke your H-1B and you can try to transfer even earlier. Hopefully that will work out. Okay. But if they revoke your H-1B before October 1st, then you are back in the lottery problem. Let's see. The question is, I'm currently on F1 STEM OPT employed by company A. They filed registration. Lottery registration was selected. Employment is ending in May. I have another job from company B. I wonder if I file a premium processing for my employer A and if it gets approved, is it possible to transfer? And the answer is, well, it's better than nothing, but it's not the ideal situation. And especially if you can request the employer A not to get your, not to revoke your H-1B before October 1st, you might still have a case. Okay. But the problem is, why would the employer A want to spend thousands of dollars on doing your H-1B? And it's illegal for you to pay for it. So don't get involved with something like that. Press *5 if you have a follow-up question. Press *5. All right. So this one is Virginia. Yeah, Virginia, go ahead. I can hear you.
Hi, sir. Hi, sir. So this is related to the question number 2, sir. Actually, so during that time I am in mute. So because right, sir, my 7th year is extension is approved for till Jan 24. So before 1 or 2 weeks back, my PAM is denied. So after that, they apply for the 8-year extension, and that is got approved actually. So in this case, what are your suggestions, sir? You want to go leave the US, or you have to apply for amendment and correct it again? So what is the option, sir, actually?
No, I think you should file an appeal, a Perm appeal. And while the appeal is pending, the appeal will stay pending for 3.5 years. While the appeal is pending, start a new Perm application, start a new prevailing wage. That will take a few months, 8-10 months. Do the advertising, and in the meantime, get another H-1B extension. So work out the timing with your lawyers. It begins with an appeal. File an appeal to Balka. Okay.
I think they said that they went not up to the just denied. After that, they're not do anything that time actually. So then they're not give any information about your PAM is appealed or not actually. So they're not made any appeal against the PAM denial, but they filed only for the extension, for 8th extension. So during that time, they filing for the new PAM. That's what they communicated to me.
How much time do you have left on your H-1B?
So, sir, actually, already I completed the 6th year. So 7th year also approved, and 7th year also completed. Now I'm currently in the 8th year extension.
Okay.
So that is also approved actually.
So you don't have enough time, right, to wait for the second Perm to be approved, I-140 to be approved. So I don't know what the employer
Yeah,
is.
sir. They said you can apply the PAM first, then you can leave the US. That's what they suggested to me because that's what they filed for 8 years. So
that's not a very smart way of doing things. But I won't second guess somebody else's strategy. All I can tell you is that that's not the way I would have done it. I'm not sure what else I can tell you. If that's what they want you to do, that's perfectly legal. Nothing illegal about going and coming back. All right.
Okay, sir. So that means I can file the PAM. I can leave the US, right? So once the new PAM is approved, then I can come back, right? So what I can do for the current approved petition, sir? Because it is approved for 3 years, right? So I can.
Yeah, I told you that is a mistake. You can't take advantage of the government's mistake.
Okay.
All right. So you think of it as one year.
I can withdraw that H-1B, sir. So
no. You can the employer will withdraw it once you leave US.
Okay, so they will take care of that, right?
Yeah, they have to.
Okay.
That is the law. Okay.
Okay, understood. Thank you.
Good luck, sir. All right. So yeah, it's everybody has their own take. I don't know why anybody would do that, but it is what it is. So question number 6. L1 maxing out August 25. H1B with March 25 lottery and approved I-140. L1 is completing 6 years in August. So it's L1A. You have 7 years. I-140 is already approved. If H1B is picked up in March, can the candidate get H1B approval based upon I-140? I think you can. Okay. I haven't looked at the regulations, and if I remember correctly, we've done that. So yeah, have it double checked because law is full of surprises. Just have it double checked, but I think you can. You should be able to get, based upon the I-140, H-1B extensions beyond 6 years. Okay. *5, if you have a follow-up question, press *5. It's an interesting problem. I don't know, but certainly worth a try. Colorado, go ahead, I can hear you. Colorado.
Hi, Rajiv. So the question was regarding on October, by October 1st, 2025, the 6 year will be completed, right?
The 6 year on L1A, now? On L1A, right?
Yes. If we, the rule, right, if we convert from L1 to H1, the L1 years also count. And
they are subtracted.
Years, you cannot.
No, I understand the problem. Don't have to define the problem for me. You've never been on H1B. You've never been on H1B. 6 years are already over. Can you still get H1B extension based upon the I-140? I think it's worth a shot. I'm not aware of any law that says that you cannot. Okay.
Yeah. Why I was asking, because when the petition would be filed, then the 6 years won't complete. But by 1st October, it will complete. So in this situation, you are saying it's worth a shot, right?
I think it's worth a shot. Absolutely. All right.
Okay. Thank you.
Good luck. Okay, let's go on to next question, which is number 7. Cap-exempt H-1B and L-1B for spouse, risks and benefits for pending EB-1B. I got married after my EB-1B was approved. I'd already applied for I-485. Currently employed in tech R&D sector related to my field. Now looking for ways to live together with my family without relying on priority date problems. Okay. My spouse is a doctor currently living in India and was hoping to come to residency in USA on J visa, which also requires observership training. B1, B2 was not approved. I was told I cannot apply for O1 since there is a risk I may not be allowed entry with pending I-485. No. Have that double checked. I'm pretty sure O1 is a dual intent visa, or as close to dual intent as you can, because I have received O1As even with 485 pending. So O1A visas as well as O1A change of status. So I don't think that should be a problem. So have that double checked, okay? I think O1, for all practical intents and purposes, is a dual intent visa. Press *5 if you have a follow-up question. Press *5. I can also do a non-profit research. Okay, you have a bunch of other questions also. My options are limited and require your suggestions if there's something that might work better. Cap-exempt H-1B H4 for spouse. Sure, that can work. I want to know if I can have concurrent H-1Bs with cap subject employers simultaneously. Oh, this is a long discussion. I won't be able to cover it in the little time that we have here. L1 requires current employer manager to approve and support if I-485 can be maintained during 1 year outside the US. Maybe. With the current advanced paroles, it might be. But would that job still be open? That's the question, the one that got you your EB-1B. Non-immigrant visa for spouse. Yeah, the J visa is very problematic because it has a home residency requirement. Unfortunately, your questions are require a very lengthy discussion. I would suggest you talk to your own lawyers. And if not, you can set up a call with us. But this is not something I can, there are so many pros and cons on every side of this question. So to me, it doesn't make sense to even think about a J1. All right, let's go on to the next question, which is question number, is there a follow-up on this? Press *5. Any follow-ups on this? Okay. Let's go to question number 8. Dismissed domestic violence charge, impact on visa stamping. I had a domestic violence charge in 2021 that got dismissed in pre-trial. Then you went through anger management classes. Okay, so this is a complicated situation. Whenever there is any kind of a criminal situation involved, I always tell people, don't talk to me, talk to a lawyer in the state where the crime or the alleged crime occurred. And the lawyer that you talked with, of course, you have the criminal defense lawyer, but you should also speak with a lawyer who does deportation defense, also called removal defense, because they are the ones who understand the state law better than we have to go and study it. I'm not even sure if it's ethical for us to talk about state law. There is a problem crossing over from immigration law, which is federal, and we can practice anywhere, to state law, which is criminal. Okay, so I would say talk to a deportation defense counsel. Now, leaving that aside, if all that was taken care of, does a dismissed domestic violence case impact visa stamping? Normally, no. Now remember, depending upon your case and what the dismissal looked like and whether there was a plea deal, you will always have to reveal, if there's a question, have you been arrested? You have to say yes. Were you charged? You have to say yes. And were you convicted? And again, depending upon what the removal defense or deportation defense lawyer says, I think that question can be answered as a no. Is it, so I don't know how long it would take and what the consulate would want to know. Is it enough I carry the certified disposition? I usually have you carry also a letter from the counsel who provided deportation advice, so that it can be explained to the consulate that this is not a inadmissibility offense. You can come back. Should I bring the police report? Usually they just want the certified copy of the court disposition, but how could it hurt? Get everything that you can and keep it in case they want it. Press *5. If you have a follow-up question, press *5. Okay. Moving on to question number 9. Expiring passport, 1 year left, visa stamping duration based upon 797. My passport is expiring in a year. My 797 is valid for 3 years. If I go for stamping, will I get a visa for 3 years? They won't give you a visa beyond your passport. So just get your passport extended. Yeah, and you should be able to do, yours could be Dropbox and hers might be in person. But there are two kinds of Dropboxes. One is based upon the visa having expired within the last 2 years, and the other one is based upon you applying from home country, never having been denied a visa, and having received at least one visa in any category. you are entitled to an interview waiver. So both of them are Dropbox situations. What are the possible options and scenarios? Just send an email to the consulate. I think she qualifies for an interview waiver. So you qualify either for an interview waiver or for Dropbox because of the visa in the same category not having expired for 2 years. These are two separate classes. Okay, one is interview waiver, the other one is the old Dropbox. So I think both of you might qualify. Double check with the consulate. Any follow-up questions? Press *5, please. Any follow-up questions? Question number 10. Maintaining status after OPT, Day 1 CPT with pending green card. My company applied for my green card while I'm on my OPT, STEM OPT. I'm not from India or China. Okay, good. I-485 was filed more than 6 months. Last date of STEM OPT is June 15th. Priority date is current. Work authorization is also approved. Can I continue working? Yeah, because if you have your EAD valid, your EAD through 485 valid, you can continue working on that. Absolutely. Is it okay to enroll in Day 1 CPT while I-485 is pending? No negative impact. You can do that. But why do you need it? You have your 485 EAD. My concern is that if 485 EAD gets denied, I will have no status. Well, why would it get denied? I mean, 485s hardly ever get denied. Very, very rarely. But can you get an EAD, STEM OPT? I don't see why not. I think you should be able to double check with your DSO. Even with the 485 EAD, you could still work on STEM OPT. One thing though, I just thought of that. For CPT, you need to have full course load, right? Will you be able to do that while you are also working? So I don't know if you can do that. So then I think you can get a STEM OPT as well. Press *5 if you have a follow-up question. Press *5. Question number 11. Disabled child aging out. My son is 17, British-born, British citizen, but parents are born in India. He has learning disabilities. He has been in the US for more than 10 years. You know, I'm trying to think of the rules for cross-chargeability. I don't think that would help because you can't cross-charge to your son. I can't think of anything else, sir. You can just keep extending his... when he ages out, what you do is convert him to B2 status, okay? And keep extending that B2. Government should allow that. We've done that for many people, many times. So it should work out. There are no guarantees, but I think a child in this situation is a very appropriate and sympathetic case for a B2 when they are aging out. So you should be okay. I'm not worried about it. Press *5 if you have a follow-up question. Press *5. All right, so this one is area code 715, Wisconsin. Yeah, Wisconsin, go ahead, I can hear you.
Hello, Rajiv ji. This is Maithili. I posted this question.
Ji, ma'am.
So you mentioned about A2. Thank you for answering this question.
Ji.
So how long he can stay?
Well, I have done it. I have done it for 5 years maximum. I mean, there's no limit. It's as long as the government allows it. Okay. So what they do is...
Does he have to exit?
No. You keep getting the B2 extended. So you make it clear. I would say get a lawyer in the beginning for the first B2. Then you can keep filing the same paperwork every 6 months. Now, what happens is there is a provision in the State Department's standard operating procedures, which is under the same heading as cohabiting partners. So what the idea is, what if there's a gay couple, they are living in Saudi Arabia where gay marriages are not allowed, right? And one partner moves to India on H1 because they are, moves to USA on H1 because they are not married, the other partner can't get H4. So they said in these cases, just come on a B2, we'll keep extending the B2. And then they took it further and they said not only that, but any relative who is not qualified for H4, but they are living with you, like mother, parents, and even I would say natural corollary is aging out child, we are going to give them the same courtesy. So consulate made that rule, but usually USCIS accepts that and follows the same idea. Okay.
And we can file him at a later date under F2B.
No. You will apply for his B2, B as in boy, B2, like a tourist visa.
Sure. Okay. So I guess my question is, will he ever be able to come back to our green card application if our priority date becomes current?
If he's aging out, the answer is no. You will have to apply for him as a unmarried child of a green card holder once you get your green card.
And that will be several years we are talking.
Yeah, it'll take several years, and hopefully you can keep extending the B2 for as long as it takes.
Sure. And any idea is there a separate country cap for British citizen, or is it different or same?
So when you apply for him, he should come under British quota. Okay. So that should be a bit quicker than it is for India. Okay.
Okay. I didn't know if there was any difference. But
no, I think there is a difference. I don't have the chart in front of me, but I think there is a difference. All right.
Okay.
Good luck.
Yeah.
Good luck, ma'am. Okay. So let's move on to the next question. Oh, we already did this one. So I think we are on the last question now. Then we'll take new questions. So this was detained at entry, wife's F1 violation and husband facing consequences. Achha ji. My friend was working on H-1B last 6 years, came to USA about 10 years back on F1. He got married recently. Wife came to USA on B1, B2, transferred to F1. After wedding, she was moved to H4. They both went to India, got their visa. They were detained at the airport, asked for their phones. My friend was notified they found evidence, wife's phone, that she violated her F1 status. They gave two options: face deportation with ban or sign some papers with deportation with no ban. He signed the papers, or he should not have signed the papers, because there's nothing he did wrong. I certainly don't think that's appropriate. I would say, set up a consultation, have your lawyers go over your paperwork and see what they suggest. But this certainly doesn't sound like a good outcome. It shouldn't have been like that. I don't think he should have signed those papers, but it is what it is. So just talk with the lawyer, see what can be done. *5. If there's a follow-up question, press *5. Anybody has any question, press *5. Anyone has any question, new questions also, press *5. Oh, that's amazing. Did we cover all the questions? Just one question? Oh, one question I can do in my sleep, no problem. Okay, area code 407 is Florida. 2 questions, okay. Florida, go ahead, I can hear you.
Hello, Rajiv sir. I just wanted to ask you a very rumor-related question. My wife's F2 visa was rejected in Pakistan in February.
Okay.
And one of the reasons that I saw that happening was because my I-20 date was August 2023.
Okay.
Sorry, August 2024, not 25.
So it's expiring this year.
Right now I have the OPT.
Ji.
I'm sorry?
They saw that it was expiring this year.
Yes.
Achha.
So it was just 6 months in my program. I got married recently in December.
Ji.
So of course I couldn't have done that any sooner.
Right.
Now I have my OPT recommended I-20,
okay,
which is ending on August 2025.
Okay.
So a lot of people are telling me, including one lawyer, that you should wait for H-1B or you should wait for STEM to get 2 years.
Hold on one second. Hold on one second. When they denied the F2, what was the ground? Was it 214B?
Yes.
You wait for the H-1B. They won't give her an F2 easily. The reason they denied her is because they say you are going to convert to a green card. It has nothing to do with your student status. Okay?
Okay.
Good luck.
Thank you.
You're welcome. California, go ahead. I can hear you. California 310, I can hear you.
Rajiv, I just asked a question, but I have one more question. Is it okay?
What was the question? I'm sorry, I don't remember what you asked.
So Rajiv, before that I asked about the EAD extension, about the green card, and you answered it.
Oh yeah, you have you have.
Other person.
Okay, yeah, go ahead. What is the other question? Go ahead.
So Rajiv, I qualified for 180 and 540, and my because of my H1 is getting expired in September. So after my expiry of H1, if 85, my EAD is denied or something, not for 85 but the EAD. The status.
Okay, so if somebody has a 485 pending, and for whatever reason their EAD gets denied, that should not affect the 485, unless the EAD is being denied because the 485 was denied. So denial of an EAD by itself has no impact on the 485. Okay.
And my H1 also will be expiring in September.
Yeah, you won't have the ability to work, but your EAD denial does not impact your continuity of your green card or your ability to stay in the US. Okay, but EADs hold on. EADs don't get denied. I mean, and there could be a small mistake or something that you can always correct by refiling, but EADs are not like independent applications that get denied. So I'm not that. That's a very unheard of scenario. I've never heard of it. Okay.
Rajiv, I have one more question.
Make it really quick.
Question. Nothing but Rajiv. After this, my expiry of September 2024, I still work regularly, right? Without my with my expired EAD also, because I have already applied.
Yeah. You are entitled to. Yes, sir. Absolutely. Okay.
Thank you very much.
Good luck. Another one from California. This one is area code 408. California, go ahead, please.
Hi Rajiv ji. I asked you earlier a question regarding location change for.
Your green card I-140 location change. Yeah, I got that. That $40,000 or $20,000. What nonsense. Okay.
Yeah, 20 to 40,000. So thank you for taking the question. So I just want to quickly check. You said there should be we should refile the I-140 in case of a location change.
No.
There are other options.
No. This is a long discussion. Now, why don't you wait? I have one more caller before you. I can spend a couple of minutes with you after that. Okay, hold on 1 second.
Sure.
And this is area code 682. Kidhar gaya? Texas. Area code 682. Please go ahead.
Yeah. So the question is that what for COS change of status from H1 H4 to B2, what is the home ties document I have to send in to the USCIS?
There are usually no home ties documents required. Okay. If you look at the form I-539, just answer the questions and attach the evidence it asks you to attach. Because when you are an H-1B, how are you going to have home ties? You don't have a home you have parents and family and all that. All you can do is write a cover letter. And if you go to my blog, it tells you what should the cover letter say. Okay.
Understood. Got it.
Good luck.
Thank you.
You're welcome. Okay. So there was somebody from California. Could you please raise your hand again, *5? Somebody I was talking to, I said I'll get back to you. Okay. Here we go. All right. So I'll explain this to you because this call is being recorded. I'll just take 1 minute because I have another person waiting.
Sure.
So I'll just give you the 1 minute overview. So when you file a Perm application, there is a way you file it and it depends upon how you file it. So Normally, if I have a consulting job, I will always file it as a traveling employee who could be anywhere in the US, but their job is hypothetically, in such a case, supposed to be located in the headquarters. So let's say my company is headquartered in San Jose, but I am working in Maryland. Okay, so if I in that case, if I move from Maryland to Delaware, let's say your spouse lives in Delaware, you move to Delaware. So you moved from Maryland to Delaware, but because the company is headquartered in California, and I filed the Perm, the lawyer filed the Perm saying that the job is hypothetically located in California because he keeps moving around, I have to do nothing. No change in I-140, nothing. I only have to amend the H-1B. Okay. Now, another possibility is, hang on, let me finish. Another possibility is, for whatever reason, they have said, no, the job is headquartered not in California, but in Maryland. And you were previously working in Maryland. What if you move to Delaware? Do I have to start everything all over again? Not if you intend to come back to Maryland when you get your green card. So there are two possibilities. One is a future job and the other one is headquarter job. Go ahead with your question.
Okay. So thanks for telling me that. So that's what my question was about. So currently my I-140 is approved in Chicago location. That's my headquarters. Mm-hmm. If I temporarily move to Portland until my wife's green card process is completed and come back in future,
no big deal. Just make sure you get your H-1B amendment. Rest everything should not be a problem. Talk to your lawyers. This is not making any sense to me.
Okay. So so there would be no scenario of refiling the I-140 in case if I'm opting to come back to the headquarters Chicago location in future.
Absolutely. I have many cases like that. Happens. Okay. There are times when the employer will say there is no possibility of a relocation. So please file the job as, not headquartered, but wherever our branch office is located. And then the employee ends up moving.
Okay.
We continue with the green card with the commitment that the employee is coming back. Okay.
And the reason I asked this because this location where my wife, they're falling back to office is 2,000 miles away.
Yeah.
But like you said, if I'm intending to move back in future to the same headquarter location, then it should be filed. Okay.
Absolutely. Good luck to you, sir.
Thank you.
You're welcome. Okay. Now, the last question for the day, I will not be taking any more. There's only one more hand up. This is Virginia. Okay, Virginia, go ahead, please. What is your question?
Hi, Rajiv. So this is a follow-up question on the question number 2, impact on the PAN renewal and the 8th year extension, right? So,
hold on. Yeah. Question number 2, 3, 2. Oh, Perm denial. Yes. Keep going.
Yes. So in this case, right, my employer filed the PAN within 1 or 2 weeks. So after that, I can change to B2 visa. I can stay till my PAM approved. I can change the status to B2 status.
You can certainly apply for it. This is a long story, sir. You should really be talking to your lawyers because there are so many components to discuss in this. I would be doing you a disservice by giving you quick advice. Simply because there are so many different ways to handle this. I think this case is being handled incorrectly, in my view.
Okay.
There was a way to handle this without you having to go outside USA even for 1 day. Okay. So, and that should have been through appeal. First file an appeal, then keep getting your H-1B extensions and keep preparing for the PERM filing. Just before filing the second PERM, withdraw the appeal and then file the second PERM. So many ways to do it, but this is the best way. Also, have your lawyers look at your resume, see if they can file a national interest waiver for you. Okay.
Can you repeat the question, sir?
Have your lawyers look at your resume to see if they can file a national interest waiver for you. Okay.
I not checked that option, sir, because...
Sir, I'm not going to be able to cover... I have to go. I have people waiting for me. I have given you have a lawyer, you are represented, talk to them. If you want a second opinion, make a consultation appointment with another lawyer, including us if you want. But I will not be able to cover the amount of stuff that we have to cover and the ideas. They can't be done in this call. Okay? So you need to get back to your own. All right. Good luck, sir.
Okay, sir.
All right.
Thank you.
You're welcome. Sorry, folks, typically we need to spend several minutes, at least 10 to 15 minutes with each person. We can't do it in this call. We can only give you quick suggestions. Sometimes we can solve a problem in that much time, sometimes we cannot. So if you are represented by lawyers, take my ideas, go talk to them. Why do you want to spend money on a consultation? See what they say. And if you're not convinced, then you can always set up a call with us. All right, folks, I'll see you again. Next week, we'll be talking on LinkedIn. That's a little bit different format. So always a pleasure talking to all of you. We'll have the recording up in the next couple of days. Take care, everyone. Bye-bye.